The recent judgment of the Supreme Court in Gurwinder Singh vs State of Punjab 1 holds the view that jail is the rule and bail is the exception. In Unlawful Activities, Prevention Act, 1967, UAPA, cases, the court observes. R18. The conventional idea in bail jurisprudence vis ordinary penal offences that the discretion of courts must tilt in favour of the oft-quoted phrase, bail is the rule, jail is the exception, unless circumstances justify otherwise, does not find any place while dealing with bail applications under OP Act. The exercise of the general power to grant bail under the OP Act is severely restrictive in scope. The form of the words used in proviso to Section 43d(5) shall not be released in contrast with the form of the words as found in Section 437(1) Code of Criminal Procedure, may be released suggests the intention of the legislature to make bail, the exception, and jail, the rule. No doubt, the menace of terrorism must be suppressed with iron hands. The dreaded criminals of terrorism are a threat to the progress of every nation and lives of innocent people. Nonetheless, it is inevitable to assess how far the goal aimed are achieved by the introduction of laws to deal with it. The UPA originally came into force in 1967 to impose reasonable restrictions on the associations. Until 2004, the subject of terrorism was foreign to the UPA. Formerly, the Terrorist and Disruptive Activities, Prevention Act, 1987, (TADA), was enacted to deal with the terrorism. It was a sunset law. Later, the Prevention of Terrorism Act, 2002, POTA, replaced the TADA. The major problem faced by those laws was that the investigating agencies were copiously misusing it. Unlike the two former acts, in UPA, the legislature put an emphatic embargo on granting bail. In both TADA and POTA, bail jurisdiction was drastic, yet, the hands of the courts were not tied. As discussed in Gurwinder Singh, the courts are restrained from releasing the accused on bail in UPA cases, if the accusation is prima facie true. Though it is much debated, in my opinion, there needs to be more on the topic, particularly to assess how much the law is concomitant to the constitutional values. The draconian TADA and POTA. Though the TADA was used very rampantly by the police, only less than 3% of the cases ended in conviction. Most of the cases were proved to be either false or cases where the stringent law was unnecessarily invoked to give it the color of a terrorist case. When the constitutional validity of the TADA was challenged in Kartar Singh vs State of Punjab 2, the Supreme Court observed. R262. It is true that on many occasions, we have come across cases wherein the prosecution unjustifiably invokes the provisions of the TADA Act with an oblique motive of depriving the accused persons from getting bail, and in some occasions when the courts are inclined to grant bail in cases registered under ordinary criminal law, the investigating officers, in order to circumvent the authority of the courts, invoke the provisions of the TADA Act. This kind of invocation of the provisions of TADA in cases, the facts of which do not warrant, is nothing but sheer misuse and abuse of the Act by the police. Then, the POTA came into force. The prime exponents of that law later expressed their remorse and difference of opinion. The Hindu dated July 16, 2004 reported. Our eminent lawyer Ram Jethmalani said today, on 15 July 2004, while releasing People's Tribunal report, that his support for the Prevention of Terrorism Act, POTA, was an important mistake made by him. He called it a terrifying act that must be repealed. Lock, stock and barrel are broken. I was a very harsh critic of the Terrorist and Disruptive Activities, Prevention Act, TADA, and when I was a member of the Rajya Sabha, I made a compassionate appeal to repeal it. But all the arguments I made to discontinue TADA can apply to POTA. I'm glad that I have got this opportunity to publicly apologize for supporting POTA, broken bar. I did support the enactment of the act, but I now realize it was a serious mistake. I did not realize that such draconian power should not be given to the investigating agencies and police. This power has been misused and very badly, so much so that the debits balance of the act overwhelms its advantages. I am glad the new government is bound by its manifesto to repeal the act, and I believe it shall be fulfilled soon, he said. The statement by Justice V.R. Krishna Iyer on the stringency of the TADA is very relevant. When reckless liberalism is writ large on the face of the enactment, the scrutiny of its legality also has to be too stern and searching to be scared into cowardly surrender merely because of patriotic phrases like unity, integrity, security or sovereignty of India, or dreadful diction like terrorism, bomb, dynamite, and explosives, which may create terror in a panicky or pusillanimous judiciary. 3. Subsequently, on the day when the POTA was repealed, most of the provisions from that law have been incorporated in the UPA by an amendment. Review committees. One of the salient features of the TADA and the POTA was that review committees were formed to evaluate whether the provisions of those laws were invoked properly. That feature was first introduced as directed by the Supreme Court in Kartar Singh. Even though the Supreme Court upheld its constitutional validity, the court was vigilant about the possibility of misuse of the TADA. To mitigate the possibility of misuse of the law, the court directed to form review committees at different levels for the purpose of reviewing the cases registered under that act to find whether prima facie case existed in those cases, if and when the aggrieved parties approached the committees. Subsequently, when the TADA was repealed and enacted the POTA, the provision for such committees was made part of the Act, Section 60, itself. As major provisions and the definitions in the UPA are not much different from the TADA and POTA, but rather more extensive than the same, the scope for misuse is there, and hence it is necessary to have a provision for review committees also inserted in the UPA. But, unfortunately, when the UPA was amended to incorporate the majority of the provisions of the POTA and amended from time to time, the provision for the review committees was not made part of it. Subsequent amendments to UPA. By the amendment of the UPA in 2008, 2012 and in 2019, more teeth were added to it. In 2008, the stringent provisions of bail were added. Section 43D5, as discussed in Gurwinder Singh, is to deny the bail in all cases of UPA, when there exists a prima facie truthful case. The 2008 amendment introduced Section 43D, along with other provisions. In 2012, Act 3 of 2013, another amendment came with the introduction of economic security so that the production, circulation etc. of high-quality counterfeit currency notes are included within the meaning of terrorism. The 2019 amendment aimed to include individual terrorists in the 4th schedule of the Act. UPA, prone to misuse. The UPA can easily be misused by the police. In cases where, naturally, there is no scope for invoking the law of terrorism, provisions of the UPA can be incorporated and make the accusations prima facie true at the ipse dixit of the police. A glaring example is that, even before the amendment in 2012, the National Investigation Agency, NIA, used to incorporate Section 15/16 of the UPA with an interpretation that the circulation of counterfeit currency notes is the indirect destruction of genuine currency in the economy, and thus the law as such was retracted. In fact, a division bench of the High Court of Kerala, in Sharif E. State 4, accepted the above interpretation. The faulty legal position continued till the full bench, per majority, 3-1, in Abdul Salam vs. Nia 5, overruling division bench judgment. In several other cases, it became later evident that the charges of terrorism were invoked improperly. In an article written by Shri Vignesh Radha Krishnan titled Data, UPA, PMLA, Section 153A, Rise in Cases, Low on Convictions 6, published by The Hindu, it was reported. Are the Unlawful Activities, Prevention, Act, UAPA, Prevention of Money Laundering Act, PMLA, and Section 153A of the Indian Penal Code, promoting enmity between different groups on grounds of religion, race, place of birth, residence, have a common link. In recent days, cases filed under these laws and section are rising, while convictions have remained poor. Under the UPA, 4,690 persons were arrested between 2018 and 2020, but only 3% were convicted. Our broken bar, our broken bar, our broken bar, our broken bar, our broken bar. Moreover, under the UPA and PMLA, getting bail is tough, and so the accused spend most of the trial period inside prison. For instance, of the 1,338 persons arrested under the UPA in UP between 2018 and 2020, only 6% got convicted, while none of the other 94% got bailed out. So even in cases where the scope for the application of the UPA is not there, the police used to see that the accused are kept behind bars without bail owing to the implementation of the stringent provisions of law. It is worth noting that many of the accused involved in Bhima Koregaon 7 case were released after more than 5 years of their custody, mostly with observation that there does not exist prima facie case against them. The corollary is that they were undergoing custody for long without adequate reason solely due to the mandate of Section 43D5 of the UPA. Misusing a harsh law is more dangerous than misusing an ordinary law. More so, if the law is used in cases not related to acts of terrorism, it will be doing injustice to the law itself. Bail in UPA, an embargo, but not under the Constitution. Even if the bail under UPA is not acceptable, while interpreting the constitutional mandate, the Supreme Court in several cases has taken the view that bail under UPA is not an unreachable one. For instance, in Union of India, UOI, versus K. Energy Bait, while dismissing the appeal filed by the NIA, held. 18. It is thus clear to us that the presence of statutory restrictions like Section 43D5 of UPA per se does not oust the ability of constitutional courts to grant bail on grounds of violation of Part 3 of the Constitution. Indeed, both the restrictions under a statute as well as the powers exercisable under constitutional jurisdiction can be well harmonized. Whereas at commencement of proceedings, courts are expected to appreciate the legislative policy against grant of bail, but the rigors of such provisions will melt down where there is no likelihood of trial being completed within a reasonable time and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would safeguard against the possibility of provisions like Section 43D5 of UPA being used as the sole metric for denial of bail or for wholesale breach of constitutional right to speedy trial. And, if it is viewed that the UPA would prevail over all the other provisions of bail, as the way the Section 43D5 of the UPA is enacted, it can even be appraised that default bail, under Section 167(2) of the Code of Criminal Procedure, is not applicable to the cases of the UPA when there appears that the accusation is prima facie true, owing to non-obstante clause notwithstanding anything contained in the code, is used in Section 43D5. Despite that, the Supreme Court in several cases, like Syed Mohammad Ahmad Qasmi v. State 9(1) under UPA, and in Sanjay Dutt v. State through CBI 10, a case under TADA, held that the bail as envisaged under Section 167(2) of the SAPC is applicable in these cases. Inordinate delay in trial. Section 21(2) of the National Investigation Agency Act, 2008 stipulates that every appeal preferred under that provision, all the appeals respecting UPA may come within this realm, be heard, preferably, and disposed of within 3 months of its admission. Neither under the UPA nor under the NIA Act is there a time stipulation for the completion of an investigation or trial. There has to be a specification to complete the trial within a fixed time after the filing of the final report. In the absence of such a mandate, the trial in such cases would prolong for a long time. This would act as legal but unjustifiable incarceration in cases where the accused are denied bail and acquitted later for lack of evidence. If a survey is conducted, it could be seen that majority of the cases under the UPA are pending awaiting trial for many years, but some are for decades, and in many cases the accused were constrained to plead guilty for this reason alone. The law declared in Gurwinder Singh. The Supreme Court and Gurwinder Singh, drawing support from another decision in National Investigation Agency v. Zahur Ahmad Shawatali 11, enumerated the situations in which the court can find the accusations against the accused to be prima facie true. Several situations are mentioned there. It is not the case that the decision in Gurwinder Singh is wrong. Due to the harsh nature of the bail provision, adhering to the literal interpretation of the provision, even the Supreme Court does not have the statutory power to release the accused. The bail jurisdiction of the UPA has to be developed more from a constitutional perspective, as the law is misused very much. The trials are being prolonged for years. And also, many of the cases are destined to end up in acquittal. Need to expand the horizon of bail law in UPA. The Supreme Court and the jurists have often observed that aspects of terrorism cannot be easily defined. The Supreme Court in Muhammad Khalid vs. State of West Bengal 12, has observed. As noted at the outset, it is not possible to precisely define terrorism. Finding a definition of terrorism has haunted countries for decades. A first attempt to arrive at an internationally acceptable definition was made under the League of Nations, but the convention drafted in 1937 never came into existence. The UN member states still have no agreed-upon definition. Terminology consensus would, however, be necessary for a single comprehensive convention on terrorism, which some countries favor in place of the present 12 piecemeal conventions and protocols. The lack of agreement on a definition of terrorism has been a major obstacle to meaningful international countermeasures. Cynics have often commented that one state's terrorist is another state's freedom fighter. If terrorism is defined strictly in terms of attacks on non-military targets, a number of attacks on military installations and soldiers' residence could not be included in the statistics. Broken bar. The aspect of terrorism involves so many features. It may be motivated by the indoctrination of radical philosophical ideas, it may be supported by acute violence, it may involve ideas to overthrow governments, and the people involved in such activities are of several types. They may incite violence, they may create terror among the people, and they may sometimes merely propagate ideology. The UPA defines the terrorist act in an invariable manner to include all types of activities that are, in a nutshell, prejudicial to the national interest. Based on such a definition, other provisions like custody, bail, punishments, and dealing with the properties of the accused and the properties derived from the terrorist acts, etc. are drafted. The terror cases and the persons involved therein can be categorized into different types without prejudice to the present definition. On one side, they belong to the extreme types of hardcore criminals, who are always involved in violence like using bombs and striking terror in the people, and on the other side, the accused are involved in socio-political activities, working among the backward and poorest, maybe with a view to propagate ideas prejudicial to the nation and the policies of the government. They can be political activists, journalists, students, cartoonists, opposition leaders, etc. The release of the accused involved in violent activities on bail would be a potential threat to the people and the nation. But the accused in other categories, just with an accusation of prima facie case, and denying them bail without differentiating them and their roles would sometimes violate the ultimate justice, guaranteed by our Constitution. Whatever may be the rigor of the criminal statute, an accused is still just a person alleged to have committed an offense. When the law is susceptible to misinterpretation and misuse and the scope for keeping the accused in jail without bail, even in cases where the prospect of conviction is wide, it may be desirable to relax the law of bail in the upper, based on some well-founded categorization, but not limited to categories made herein, though the accusation appears to be prima facie true. As the law is intransigent, the categorization can be made by only the Constitutional Court spy on the touchstone of the constitutional provisions. Abdul Qadir Khanju, S. is the author of the Commentaries on the Unlawful Activities, Prevention, Act, 1967, published by the Asia Law House, Hyderabad. Views are personal. 1. 2024 Live Law, SC, 100. 2. 1994 3 SCC 569, Manu/SC/1597/1994. 3. Legally Speaking, page 236, Universal, 2015 reprint. 4. 2013, 4, KHC 35. 5. 2018, 3, KHC 1, FB, Manu/K/1003/2018. 6. https://www.thehindu.com/data/data Section 153A. What do these laws have in common? Article 65871393.ek. September 10, 2022, 11:50 a.m. Updated 9:04 p.m. IST. Accessed on the 13th of February 2014. 7. Vernon v. The State of Maharashtra, 2023 Live Law, SC, 575, and other connected cases. 8. Air 2021 SC 712, 9. 2012, 12 SCC 1, 10. 1994, 5 SCC 410, 11. https://www.livelawin/pdf_upload/pdf_upload 3595998.pdf. 12. 2002 Sub 2 SCR 3.